Pakistan, for those in Asia, in Pakistan, Bangladesh, Sri Lanka, and India. We are extremely happy about this panel. And good evening also to those that are in the East Coast of the US, and perhaps good afternoon, depending on where you may be in the world. This is the panel on controversial investment awards in South Asia. And it is my pleasure to share with you a few words about the World Arbitration Update. But before that, it is my pleasure to introduce the moderator for this panel, Dr. Kabir Dougal, who is, in addition to an incredible supporter of World Arbitration Update, also a very strong attorney, arbitrator, and academic. Kabir focuses his practice on international investment arbitration, international commercial arbitration, and public international law matters, serving both as counsel and as arbitrator. He is a professor of Columbia Law School and also an international attorney in Arnold and Porter. Dr. Dougal's experience includes complex disputes under numerous bilateral, multilateral investment treaties and contracts in South Asia, Latin America, Central Asia, Middle East, Europe, and Africa. His experience flows from his triple training in international law, common law, and civil law traditions. He has served as an arbitrator in over 40 disputes involving parties from all over the world and across several different industries. Dr. Dougal has been ranked as among top 10 arbitrators for the Asia Pacific region by the Bali International Arbitration and Mediation Center, and received the 2019 Equality and Diversity Award in Dispute Resolution by Prime Dispute in 2020. In 2021, Dr. Dougal was awarded the 2020 Dispute Resolution Practitioner of the Year for the Americas. And most importantly, Dr. Dougal is also a guest lecturer in Georgetown University Law Center to my course on investment treaty arbitration, public international law, and ICJ judgments. Kabir has helped build that course, especially concerning the session on expropriation, and has been a staunch supporter of World Arbitration Update by connecting REAL, which also promotes diversity, and the World Arbitration Update. We are very pleased to have him as the moderator, and without further ado, Kabir, you have the floor.
Thank you very much, Jose. Best $20 ever spent in my life. Let me just start off by saying what a delight it is to be here. My role is actually very easy because we have an absolutely spectacular, phenomenal panel in front of you. These are truly just, I will introduce them very briefly, but these are real stalwarts. They're real people making a difference in South Asia, but in arbitration more generally. And it's a real delight to be able to get such amazing people together. Obviously, we're going to be talking about a very simple and easy topic. It's corruption, abusive treaty interpretation, and novel damages calculation. That's our agenda for today. I was kidding, in case that wasn't apparent. We are looking at very meaty issues, but we have this amazing panel that's going to share their thoughts and insights. So stay tuned, join in the conversation. let me just set the stage for what's going to come. And when we're talking about corruption, right, if we just look at some estimates, a big part of the world GDP gets lost in corruption. If you look at monetary amounts, it's huge. $2.6 trillion. That's zeros I cannot even imagine. And then you see what the World Bank tells us. Corruption robs schools and rots institutions. I put that here mainly because I felt the word rob and rot rhyme. What is the implication for us when we're talking about this topic? In arbitration, corruption has a very unique dimension because corruption can be, especially in the investment context, a sword and a shield. The state can invoke it as a defense. The state can, affirmatively try to point to corruption by the investor. You see it happening both ways. You can see the investor invoking it both ways. Just to notice that while our focus is investment arbitration, you are seeing this coming up in commercial arbitration as well. Corruption, easy to allege, difficult to prove. We will be probably looking at some of the cases in South Asia where this has become a very critical issue. But the tribunal is not a court, right? It doesn't have police powers. It cannot actually make investigations of findings. And therefore, if you see publicly known cases that have made findings on corruption, it's few and far between. The other thing we're going to talk about is what impact does damages have? And this is where we talk about the mega award, right? I think for GAR, you have to be over a threshold, and I think the threshold is 500 million to even be classified as a case. Damages can sometimes be super large. I think the example that I always find fascinating is that if you add up, and this is a few years ago, but if you added up the total amount alleged against the Czech Republic, that amount was larger than the annual budget for the Czech Ministry of Health. So we're talking about cases that can have potentially very, very large reaches. This is, again, damages. This is valuation. There's so many approaches in valuation, different valuations leading to different outcomes. Let's take a little bit of a look into that. And let's come to the regional focus that we're looking at. We're talking about South Asia. Now let's put cricket aside and let's put delicious food aside, but we're talking about a region that is about a quarter of the global world population. So definitely this is a region that we cannot ignore. We're talking about countries that are rapidly growing, but there's often corruption lurking in the background. And then for our purposes specifically, we're seeing each of the three countries playing active roles as respondents in investment arbitration, with some potentially large and controversial awards coming out in each of the three countries. Now, for countries that are developing, for countries that have issues on poverty, for countries that are thinking about infrastructure, you may have to make tough decisions when it comes to large awards. What implications will that have on your growth agenda? That's something this awesome panel is going to tease out for us. But before we do that, we'd like to invite you, especially those joining very early, or like us in New York and Boston, or DC quite late, we'd like you to join us in some polling. Maria Lucia, can we have the first poll question presented? And that's the proposition you see in front of you. Okay, folks, we invite you all to share your views. Go ahead, take it away. "57% have participated, 60. Let's try to make it 100% participation. Let us know what you think. That'll give our panel something to think about. The proposition, investment tribunals are likely the only neutral body to address serious allegations of corruption in South Asia. Still at 62. We'll give it another 10, 15 seconds, and then we'll close the poll. Let us know what you think. We're having an interesting mix here. I disagree with a slightly higher percentage than the I agree, but we have about 20% of people that are unsure of where to come out. And our panel may be successful in helping you move one way or the other. Okay, I think this is a good time to close the poll. And you can see the results. And with that, we get the poll out. Okay, now let me present the second polling question. Investment arbitration should consider a state's ability to pay when it comes to damages. These are the choices you have. I agree, I disagree, or I am undecided. We invite you to give us your initial reactions. Okay, we seem to be having a slight majority here. And that's interesting. Let's give it another few seconds. Okay, we clearly see here a preferred approach in support of the fact that tribunals should think about a state's ability to pay. There has been some recent scholarship talking about what is termed as crippling compensation. Clearly, this panel, or the representatives here, feel strongly in support of, well, I shouldn't say strong, yeah, 63%, yeah. Okay, now what's going to happen very soon? We're going to have Rekha Rangachari, the executive director of the New York International Arbitration Center, somebody I think who needs no introduction, and somebody who I'm pretty sure more than half of you get emails from, right, around the week. I'm not going to spend too much time introducing the panelists because we're going to be here all day. Look them up and connect with them on LinkedIn. I mean, I think that's a big agenda of what we're trying to accomplish with WOW. That is to make people get together and know each other. But Rekha will set the stage of what's happening globally when it comes to corruption, interpretation, and when it comes to damages. Let me just tell what's going to happen because our speakers will speak in succession and then we will have dialogue. We're going to have the three big South Asian countries with speakers from each of these countries tell us what's happening in that country. We begin with Bangladesh. We have Professor Rumana Islam, a true leader probably one of the youngest people to be nominated to ICSID's panel by Bangladesh, and a true expert. So we are very privileged to hear an authority in Bangladesh telling us what's happening in Bangladesh. We're then going to move on to Dr. Rishabh Gupta, probably the most famous arbitration lawyer in India, after having spent considerable time practicing both in New York and in London. And then we're going to hear from our own Fatima Aslam. She was in Houston. She just moved back to Lahore a week ago to be with family. Somebody who has been very active with research in Pakistan, looking at arbitration in Pakistan. Although, like all our speakers, studied in the UK, the US, it really does give us a very international perspective. She's going to tell us what's happening in Pakistan, where are we headed? Spoiler alert, some very interesting developments in Pakistan, very relevant to what we're talking about. So with that, stay tuned. Each of our 4 speakers is going to speak to us for 10, 12 minutes. We're then going to have a bit of a dialogue, so stay tuned for that. But Rekha, why don't you take it away?
Thanks so much, Kabir. A big thanks to the World Arbitration Update Organizing Committee on this inaugural week. It takes great gusto to create these sorts of thoughtful, progressive, substantive events. To Jose Antonio Rivas, Maria Lucia Casas Arguello, and many, many others, and a sincere pleasure to share the Zoom stage with all of those on the screen, Kabir, Fatima, Rishabh, and Professor Islam. So I've been tasked with giving a global overview on this topic of controversial awards. And so I'm going to address it in 2 phases. The first, the conundrum of endemic corruption internationally. And next, this conversation on mega claims and mega awards to set it up then for the jurisdictional spotlights that the rest of the speakers will take in turn. So we begin with this idea, allegations of fraud and corruption, they're often encountered in international arbitration. And scholars have said that we must take these allegations seriously and treat carefully. But what does that mean? And it's for you, the audience, to think about and chew on as we go through this session. Indeed, corruption is a powerful defense, but as Kabir already foreshadowed, it doesn't work well. Why? Of course, I'm borrowing here from one of my favorite comedians who lays out this of course, but maybe scenario. Of course, there is strong public policy against allowing such actions of corruption, fraud, or illegality in the proceedings, but maybe there is this issue of variety in language under a variety of sources, international conventions, arbitral case law, domestic law, public international law, transnational law. Transnational public policy can be esoteric in meaning, global fundamental values of justice and morality, incorporating general principles, guiding principles that can be vague and hard to define concretely case to case. Of course, there is an inherent risk allowing improprieties to go unpunished. A tribunal can make adverse inferences where a party fails to produce requested evidence. This is the most rare. They can take formal note, or they can treat evidence with skepticism. They may even address it in the costs phase of the proceedings. But maybe it is difficult to obtain direct evidence. Indeed, senior officials actively engaged in corruption are often in a position to impede investigations and destroy or conceal evidence. Consider also, there are many pathways involving fraud, bribery, and corruption, where a tribunal finds it does not have jurisdiction, where bad acts exist in relation to the investment, nullifying access to arbitration through the treaties, the limitation of the investment treaty to investments being made in accordance with the law, therewith it fails on objection to get access to arbitration, or the tribunal determines claimant cannot rely on substantive legal protections contained in the investment treaty. So towards that question that Kabir posed, the tribunal as the only neutral body. Indeed, the tribunal often finds it doesn't have jurisdiction to make these determinations. And even where it does, as Kabir posited, what is its police power? Allegations by states and against states as to corruption are only increasing. And so let's take a quick snapshot at a case that exists that you all probably know well. It is brought up often, the World Duty Free versus Kenya case, to take a look at this notion of transnational public policy as an international consensus, universal standards and accepted norms of conduct that must be applied in all fora. That is what this case stands for. In humor, the case also stands for the most expensive corn. Money given in a suitcase, corn returned in that suitcase. So quick overview for those that don't know it. 1989, an investor concludes an agreement for a construction and operation of a duty-free complex over 10 years and renewable for an additional 10. The investor alleges that as part of the president's re-election campaign, World Duty Free was used as a vehicle to obtain funds illegally without its knowledge. There's no relevant bit at application here. The investment contract selected Kenyan and English law, and to ensure the destruction of all evidence for the prosecution of fraud, the companies were taken over, allegedly based on fraudulent documents. So there's all of this fraud conversation happening, zeroing in on the alleged bribe. At the time of entering into the contract, and this is important temporally, the investor was asked to make a personal donation of $2 million in cash to the president, as this was payment for doing business with the government of Kenya, common practice alleged. The investor said this practice had cultural roots and was buttressed by the Harambee system, mobilized resources through private donations for public purpose. Ultimately, we emerge with a reinforced standard. Bribery is contrary to transnational public policy, rejecting claims subject to the corruption that ensued. An objective view of transnational public policy, surveying many aspects that come into play, the international conventions, the declarations, national court decisions, answering to this notion of culpability, an objective minimum standards of conduct for the investor, even where a host state may not comply. Investor obligations take the spotlight. Corruption is a jurisdictional barrier to gain entry to the arbitral process. Does it encourage corruption in a host state? How do you deal with proof? These are questions we're going to continue to tease out. It comes back to this idea that bribery clearly violated international public policy, as well as Kenyan and English law, both applicable in this case. The implications for the investor is that it's not legally entitled to maintain any of its pled claims. And it comes back to this: should we make a distinction between governments asking for a bribe versus a person, the investor, asking for a bribe? Where does the issue of bribery fall? What is the temporal relevance? The next tranche I'll get into is this mega claims, mega awards. So this idea of serious implications of cases becoming bigger and bigger, the claims becoming bigger, the awards rendered equally big. And in particular, this conversations ended up fixating on this wild, wild west that we call the investor state dispute settlement system, the regime, and astronomical damages. So why is there this trend? Let's map what scholars have said. So scholars, in considering this, have looked to the fact that there are few rules to curb the natural tendency to engage in strategic claim exaggeration. After rigorous dialogues of jurisdiction and liability phases, this comes out. Then mega claims are buttressed by mega reports. There's varying, perhaps lawyer comfort, dealing in damages and quantum, and lack of sufficient checks and balances. So evaluate those and see where you fall in the same way we took these polls. Ultimately, the takeaway is states cannot pay. So how do you address that? And it goes back to that polling question number 2. Is it relevant a state's ability to pay? This group found 63% in favor. Don't punish the taxpayer, right? And so this notion of possible trend of investors exaggerating claims of compensation for lost future profits, building momentum year after year, decade after decade. And so let's take the really quick snapshot. We're taking the case of Tetian versus Pakistan. This case, in conjunction with World Bank, that has put out a report on foreign direct investment and its treatment, talking also about discounted cash flow and how it doesn't account well for risk. So in this case, the tribunal created a new discount cash flow. There's a mine, it hasn't become commercial operation, so there's no track record. And so out of this case, we get this notion of modern DCF method to incorporate all project risks into the cash flow. The tribunal utilized that method, which can be speculative, which is where its criticism comes in, to look at long-term cash flow projection, look in a track record of profitability, even where one may not exist, discount the rate applied to arrive at the present cash flow value, and then assess what the risks are. And so it's this notion of there can be, when you use the DCF method, a roller coaster of emerging values as you're trying to predict cash flow over a period. Is it reliable? In this case, as I said, the new interpretation emerges. You don't need a track record of performance, and yet an award is issued, right? As I said, the mine is not operational. $4 billion are awarded before any interest, right? This is an astronomical amount, but consider also with this, Pakistan is made to pay claimants' costs of the case. We're looking at some $60 million in addition. And of note, Pakistan had just recently gotten a loan to near these amounts. So whatever it had been able to recoup, it's having to pay forward in an award and costs. It begs a question on the state's ability to pay. The benefit of expropriation of an investment for greater investor gain through arbitration. Is the system being used in an inopportune way, in a cataclysmic way even, based on the numbers being put forward? And so ultimately, and I'll close with this, we have to ask ourselves, what happens when the project is never built? What happens when the mine never realizes a revenue stream? What if there's no conceivable trajectory to assess the return on investment? And then how do we apply a discount rate to bring cash flow to present in a realistic way? What happens then as we tether between procured by bribery contracts or tainted by fraud that has been covered up? What of expropriation of for the investor's best return? And how can we ascertain a possible changing landscape of the investor-state dispute resolution system of reform that's being hotly discussed right now at the UNCITRAL's Working Group 3? What will reform mean for this process? To better it, to change it, and then we'll have to wait and see. Think also as BITs and MITs are undergoing a period of evolution, states may wish to secure reliable, effective access to a corruption defense and therewith modify the language within their BITs and MITs using preferred language. So stay tuned, more to come, more stories to be shared by our elite panel as we travel next to Bangladesh and then to India and Pakistan. Kabir, back to you. Thanks so much.
Thank you, Rekha. I think you've teased out the issues nicely, set the stage. Let's look and see what's happening in South Asia. What's happening in each of these countries? Where are we going? Professor Islam, tell us what's happening in Bangladesh. Let's fix investment arbitration in Bangladesh and move this forward. Professor, the floor is yours.
Thank you, Kabir. I hope I'm audible. Okay. A very good morning to all of you from here from Bangladesh, and thanks to Kabir for that very nice and enthusiastic introduction. If I move into the controversial levels, to be honest, Bangladesh has faced, in terms of, in comparison to India and Pakistan, quite a few ISDS cases. Let me just give you a very brief overview about the legal regime of protection of FDI, and then I move into the ISDS cases so far experienced by Bangladesh. So just before the pandemic, Bangladesh actually enjoyed quite a steady GDP growth, and there was a big flow of FDI according to the UNCTAD report, but obviously it got a very big setback due to the pandemic. And as a consequence of the pandemic, the predictable economic crisis due to the pandemic, current pandemic, it is estimated that the flow of FDI is going to reduce significantly. But in saying so, one positive thing is that the government, the current government, one of the prior focus of the government is to attract the FDI, and actually they have done all kind of things how to do that. In terms of legal regime, Bangladesh has the Foreign Private Investment Promotion and Protection Act 1980, which is a very short piece of legislation. But recently, Bangladesh enacted the Bangladesh Investment Development Authority, BIDA 2016. And since then, actually, this whole landscape of flow of FDI in Bangladesh has significantly changed quite a lot. And because it took the sole aim of BIDA was to encourage private investment in private sector, and for that they took different kind of initiatives, including one-stop services center, as well as for specialist economic zones for particular investors like Chinese investors, Japanese investors, and recently for as well as the Indian investors, right? When we talk about that, that's the national piece of legislation. At the international level, Bangladesh is signatory to the Exit Convention, New York Convention, as well as Bangladesh has its Arbitration Act of 2001, which exclusively provides for enforcement of foreign arbitral awards. So in terms of having a good legal regime, Bangladesh is all set for foreign investors. Now coming to ISDS experience, we just, if we want to be very brief about the bilateral investment treaties in Bangladesh, in fact, Bangladesh, how many BITs are there in Bangladesh? Bangladesh signed, there are different opinions, because the official body, the BIDA, states that Bangladesh has 31 BITs, whereas UNCTAD's investment policy says the country has signed 30 BITs with 28 countries. Again, if we look into the Ministry of Industry's website, it says that it has signed 33 BITs. And among these BITs, at least 4 BITs are invisible in a sense that the text is actually found nowhere. And then there are also BITs which are mentioned in the official website, but it does not correspond to other information. So I found that we have at least 4 invisible BITs in that way, that it's in the official website, but we cannot find it anywhere in the world. For example, the text of Bangladesh Cambodia BIT or Bangladesh Pakistan BIT, it could not be found anywhere. Now coming back to our main discussion about the awards that has been so far rendered against Bangladesh, in comparison to our neighbors India or Pakistan, Bangladesh has rather less number of BITs, as well as in terms of exit experience. Bangladesh so far had faced 7 claims initiated against Bangladesh by the foreign investor. And among that 7, 2 are still pending, the ones related with Nyko Resources, a Canadian company, but all the rest 5 are already concluded. And between the concluded cases, again, the ones which has actually rendered damages against Bangladesh, NPEC and NICO, the full text of the awards are yet to be publicly available. So unfortunately, I cannot make clear comments on that. But and again, one interesting point is that all of these cases are related with energy sector. All the 7 cases that has been initiated by the foreign investors relates with the energy sector. So I will just pick up 2 very controversial awards against Bangladesh. One is SAIPEM and another is NICO in terms of corruption. And in Saipan, commenting on writing on Saipan, somewhere I just titled it "When the Investor Gives You a Lemon." So Saipan was a case where Bangladesh really had a very tough experience, and it was a case in 2007. That was a time it was, in fact, Bangladesh did not have the expertise or the experience how to deal with this kind of, because investment state arbitration is something completely quite different from commercial arbitration or other international disputes. So this was the first experience that Bangladesh really had a very bad taste. Saipan, what the reason for it being controversial is that it found that the act done by the local courts was amounting to judicial expropriation. So the finding of the ICSID tribunal in Saipan is open to different criticism. First of all, the tribunal found different aspects, and it does not even go into ICSID's own standard of what is called judicial expropriation. Tribunal also rejected Bangladesh claim that the foreign investors need to exhaust local remedies for challenging judicial investment arbitration in case of denial of justice or not in the case involving judicial expropriation. And also at the same time, the assertion of expropriation by the host state's judiciary should be that enable the foreign investor to disguise its denial of justice claim and thus avoid the application of local remedies rule. And the tribunal's adoption of the legality test in addition to or in substitution to or the sole effect doctrine that has served the method of establishing expropriation is also open to criticism. And also at the same time, Saipan does also give a kind of a note of a warning or caution to all national courts exercising their supervisory jurisdiction over international arbitration. Since the alleged undue interference by the national court, it may also give rise to state liability under international law, as it was in the case of Saipan. And this very loosely articulated definition of what is called judicial expropriation that the tribunal finally concluded in Saipan. This is likely to also catch most intervention in arbitral process, despite the local court's due exercise of supervisory power for very genuine reason. And the third thing that which I find quite problematic is that one thing which is often ignored, one issue that the Saipan case, the whole project of Saipan, it was an Italian investor, and it was in fact the first case filed under a BIT, Bangladesh Italy BIT. And Saipan was a World Bank project, and the award in favor of Saipan was finally decided by ICSID, which is an institution, an integral part of the World Bank. So there is an element of structural bias that remains quite undiscussed while treating the local court's action. Second case that I would like to highlight, NICO, and NICO in fact initiated at least 4 cases against Bangladesh. 2 are still pending. 1 is finally concluded, but the final award is yet to be publicly available. I want to just focus on one award, the award on corruption. And again, with NICO, I have written somewhere, the experience of Bangladesh has been the ugly, the bad, and finally some good, because Bangladesh, in fact, lost in the initial, some of the findings by the tribunal. And then it also lost in proving the allegations against NICO on corruption. And finally, Bangladesh owned its compensation claims that was in 2020 February, I think. And finally, when it came to the compensation against Bangladesh damages claim, NICO won. So it's a mixed experience. But in terms of corruption allegation, it was a very highly, very politically hyped case, because since the allegation of corruption involved high-level officials, public officials of Bangladesh, including the BAPEX official, and then the state minister for energy, and then the prime minister as well. So the corruption allegation was based on the fact that actually this Canadian parent company, NICO Resources, they provided benefits to the then State Minister of Energy and Mineral Resources, which included a Toyota Land Cruiser and travel expenses of 5,000 Canadian dollars for non-business related troubles to attend a conference in Calgary as a guest of NICO Canada. And this allegation of corruption, when it was revealed, it was in fact investigated by the Canadian Investigation Agency, Royal Canadian Mounted Police, and the US Federal Bureau of Investigation, FBI. And in fact, the Canadian court found that NICO was guilty, and it was convicted by the Canadian court based on the statements of the fact signed by the officials of the NICO Canada. And the Alberta Court of Queen's Bench on this issue of bribing a foreign official by a Canadian company, it took that this was a serious matter, and the court's finding was that it was an embarrassment for all the Canadians, which is prejudice Canada's efforts to foster and promote effective governmental and commercial relations. And the court even further went to say that the penalty imposed must be sufficient to show that the court's denunciation of the such conduct, this is not only an embarrassment, but NICO's conduct was a dark stain on Calgary's proud reputation as the energy capital of Canada. That was the finding by Justice Scott Brooker in that case in Canada. The corruption case of NICO in Bangladesh is still going on. It's still pending. The final findings are to be decided yet. But when it came to exit arbitration, finally, after examining everything, and when Bangladesh made its argument based on good faith international public policy as devised in World Duty Free Kenya, which Rekha had actually very nicely explained, and that NICO did not bring its claim on based on clean hand principles while challenging the jurisdiction on grounds of corruption. But finally, the tribunal actually found that it applied the principle recognition of estoppel, and it actually did not find any causal connection between the alleged corruption and the contract. And finally, it decided that that there was no corruption. That was their final finding. But what is problematic here is that these observations actually gives a kind of a chilling effect and also a lack of regulatory freedom and public policy, Bangladesh as a respondent state. And also at the same time, we have to acknowledge that in terms of NICO, at least on the decision on payment to realize its area bill and gas from Petro Bangla, this is highly criticized because of lack of prompt response and due performance of the Bangladesh Council team, and particularly BAPEX, because it did not, it couldn't represent the country in the illustrated gaps, and there was inadequacy of properly arguing the competing interests of Bangladesh as a respondent state. So this was, I think, as also an example how actually developing countries learn in terms of capacity building, in terms of their council team, all these issues. So many think that due to poor representation of the country's interests, Bangladesh actually lost a distinctively winnable case. And what are the position of developing countries? There is a book by Paulson on bounded rationality and economic diplomacy, the politics of investment treaties in developing country, which actually explains very nicely. Just before I conclude, there were two poll questions just to respond. One was whether the arbitral tribunals are neutral forum, and then I see that people say disagree on that point. So that gives an impression the majority have disagreed. And on the second question, whether the capacity, I think, of the country, host country should be taken into account, and mostly agreed with that. And I'm happy to see that, because in my book, the book is on FAT, but the whole argument is that while judging calculating damages, the tribunals needs to take into account the capability of the country, especially when it comes to the host developing countries. And then I have a good whole chapter on stating different fact scenario. Even if you look into AMT versus JARI, if you look into the separate opinion, it does talk about taking into consideration all the capabilities, whether the countries are capable enough to pay those damages in the ISDS made against the foreign investor. So with this, and if we want to look forward, Bangladesh, since it's getting so many of FDIs, and with the current scenario of a pandemic, Bangladesh again had to take many regulatory measures to address the pandemic. And like many other countries, Bangladesh is also fearing of getting some of the claims from the foreign investors. And the bilateral investment regime that we have currently actually mainly represents the first generation of BITs, where we do not have enough protection like regulatory measures, non-precluded measures, general exceptions. So these are the matters that Bangladesh needs to take into account. And I think one point Rekha had highlighted already, that before you litigate, please legislate. So unless we have a very good protection in the bilateral investment treaty regimes, it becomes quite difficult when you go in the international tribunal, which in my opinion is quite inherently pro-investor oriented. It becomes very difficult for the developing country like Bangladesh to get the case in their favor. So that was all from me, and thanks once again for the wonderful, to all the panelists, wonderful panel, and I also look forward to further discussion. Thank you.
Thank you, Professor. Dr. Gupta, tell us what's happening in India. Is India similar to Bangladesh?
Thanks, Kabir. Thanks, Professor Islam, and thanks to World Arbitration Update for this. What I thought I'll do is that sort of very quickly walk you through what I think are sort of the key points in terms of the historical landscape as far as Indian BIT regime is concerned. And I wanted to sort of briefly make 5 points there. And after that, I'll spend probably 60 seconds or so talking about one case, and only just one case, Devas, because I suspect some of this would be picked up in the discussion that we have once the presentations are done. So in terms of historical update, first point, purely as a matter of fact, the first Indian BIT dates back to 1994. Not surprisingly, that was with the United Kingdom for cultural, economic reasons, important trading partner, etc. Between 1994 and 2010, nearly 80 more investment agreements, both BITs as well as free trade agreements, which have investment chapters get signed. A couple of years ago, I did a small empirical study for the Ministry of Finance to look into the advent of these BITs. And in that context, I got to quite a few officials who were actually involved in these negotiations. And not surprisingly, and this is not specific to India, not surprisingly, most of them had very little idea of precisely what they were doing. These were boilerplate treaties, perhaps developed by certain jurisdictions and then copied, pasted over. But that I don't mean in any significant criticism, because to be honest, that's how it was, not just among developing countries, but even amongst most developed countries at the time. So that's point number one, just in terms of the historical development of the regime. Point number two, most of you would know about is white industries. That's important not because of the kind of things we're talking about today. It didn't involve a large claim. It didn't involve any allegations of corruption, no multiple disputes really as such. But it was an important event for two reasons. One, white industries, just purely by way of background, involved effectively a commercial award, an ICC commercial award that was won by the investor against an Indian state-owned company, so not against the government itself. But the enforcement of that arbitration award in India took a very long time, not necessarily because of any overt intervention by the government, but just because of the way the jurisprudence was developing at the time. In any event, India lost that treaty arbitration. There were findings about how perhaps the delay in the judicial system were responsible for the investor not receiving its effective means to or effective remedies under the treaty. And that was taken quite badly by the government for a couple of reasons. One, of course, they didn't like the fact that judicial delays, which everyone in India suffers from, could somehow become a reason for an investor-state arbitration. And second, just the realization that, of course, despite the arbitration award there was as small as $4 million. It was paid up, I think, almost immediately after it was given. So that wasn't really the issue. It was more a principled issue for the government. Now, the third point, very often people say that that opened up the floodgates to other investor state claims. I sort of disagree with that. There was no floodgate as such, but what really happened is that there were a series of events which occurred, which led to a large variety of claims, both in domestic courts as well as in international tribunals. One was the cancellation of about 110 telecom licenses. The cancellation happened primarily because there were allegations of corruption and failure to follow procedures as far as allocation of spectrum was concerned. Now, that led to a large number of claims in Indian courts, also led to investor state claims. There were similar cancellation of coal block allocations, which also led to claims. And then perhaps most notoriously, there were retrospective amendments to the Indian Income Tax Act, which led to a variety of claims, both in Indian courts and outside. Quite recently, Vodafone, Kane, etc., have been in the news. All of them have been arbitration awards coming out of those retrospective amendments made back in 2011. Now, I'll just pause there for a second. I've always felt that India, the way it is structured, is perhaps most vulnerable to investor state claims. And I don't mean it in any form of criticism, but that's the way India is. And some of the points that I like to make there are, first, very large economy. For the size of the economy, these number of claims is no surprise. I mean, there's smaller economies elsewhere in the world which have far greater number of claims if you do sort of a pro rata proportionate analysis. So often people say, oh, 15 claims, 20 claims, 25 claims. For the size of the economy, that's not very large in my view. But there's a second and a third point, which is more important. India is a very strong federal structure with a very strong central government in the middle. Yeah. So what that basically means is that because from a public international perspective, you look at state, central, district governments, all as part of one unit. Decision-making, however, is happening at each of those levels. And at each of those levels is substantial autonomy. Central government, of course, has a significant role to play, but there's substantial autonomy. So it's not like, for example, in the UK, where perhaps some county somewhere can make some decisions, but ultimately everything comes back to the Whitehall. It's not like that in India. You have a central parliament, but you have very strong autonomy given to respective states, much like the US. The US would be a slightly stronger federal structure in that sense. Now, what that really means is that even if there is understanding of what the treaty obligations might be at the central level, you won't have that understanding at the state or the district level. It would never happen. So one has to be slightly conscious of that fact at every level. One has to be conscious of it at the government level, and one has to be conscious of it at the investor level. And if you look at some of the more recent claims that have come up, Nissan in relation to VAT refunds, a couple of cases that I'm doing at the moment against sort of in relation to gas allocation, where the underlying events happened in Maharashtra. Those are nothing whatsoever to do with the central government. Those are not like your Vodafone, Kane kind of cases where someone sitting in the legislature in Delhi is making decisions that let's change this retrospectively. Those are decisions being made in what I genuinely believe in a good faith form by state governments sitting in different parts of the country, not thinking about what those BIT protections might be one way or the other. So that's the second point. The third is that we have a very activist judiciary. So if you look at a large proportion of the claims that are there against India, they have very little to do with legislative or executive actions. There are examples of those, but majority of them actually come out of judicial actions. So cancellation of 2G licenses in that sense had nothing whatsoever to do with legislative or executive actions. They were all judicial actions. And you often talk about US Supreme Court, for example, being very powerful, being activist at times. It's nothing like what the Indian Supreme Court is, because the amount of involvement that the Indian Supreme Court has in daily lives of each one of us is far greater than any common law jurisdiction anywhere in the world. You pick up the Economic Times, the Indian equivalent of FT or the Wall Street Journal, every day on the front page, there'll be at least 2 Indian Supreme Court judgments highlighted. Why would a business daily have 2 Supreme Court judgments every day on the front page? That's because it affects daily business life. And if it affects daily business life, it will become a reason for investor state claims. And the judges sitting in the Supreme Court are not thinking that, oh, well, if we take this decision, this would lead to a BIT claim. They're not thinking like that. And no one is making those representations before that matter. So that's my sort of third point, that there has been a floodgate, there have been a lot of claims, but neither do I find the numbers that large given the size of the economy, nor do I find them that surprising given how India is structured, both in terms of a strong federal structure as well as an extremely activist judiciary. Now that's the third point. The fourth point is that, of course, while I may say here that none of this should be that discomforting for anyone, it was obviously discomforting for the government. And that led in 2016 to the sort of creation of the model BIT, and in 2017 of termination of a large number of. Again, my personal view is that none of it was genuinely problematic in a way. The model BIT was a nice initiative. Perhaps it went a step too far in the sense that what it effectively tried to do is to look at each and every instance of a claim against the government and try to patch holes. And in doing so, they created a document which is largely incoherent. But as an initiative, it wasn't bad at all. And I do think that in some respects, every country in the world goes through that initiative. Every developed country, whether it's the United States, UK, Germany, they've all had their own model BITs, which have become the sort of effectively the template for future negotiations. The only difference is that India perhaps went a step too far in terms of creating a document which was very one-sided and therefore hasn't really been picked up by other states in their respective negotiations with India. What followed with that is also termination of a large number of BITs. Again, as a concept, there is nothing problematic about it. Each state has the ability to terminate these BITs. India has never said that because of termination, the sunset clause would not be protected. Now, whether or not as a matter of policy, that was the right decision, we can debate that. I often think that perhaps what was most myopic about that decision is that today, India is not just a large recipient of foreign direct investment, it's a large exporter of foreign direct investment as well. There are a large number of Indian business houses who are making massive investments outside of India, often in jurisdictions which are more politically risky than South Asian countries. And you require perhaps these kinds of protections in those countries. And I see that every day in my practice, right? Clients that I have, people who are investing outside of India, do often talk about protections that may be available to them in those jurisdictions and often feel uncomfortable if those protections are limited to what either the domestic law provides or what the contractual mechanism might provide for. So I think somewhere that termination decision was rather myopic from that perspective, but otherwise I don't doubt that the state has the ability to do it and perhaps should be doing it in circumstances where it feels that the existing regime doesn't really work for it. The final point, and that's connected to what I said earlier, is that going forward, I suspect you'd continue to see a large number of investor state claims against India. That wouldn't stop. It wouldn't stop because the economy would continue to grow. Therefore, there'll be more and more investments coming into India. It wouldn't stop because the Supreme Court and the high courts in India would remain as involved in business lives, in the economy as they are today. And it wouldn't stop because you'll continue to have a very strong federal structure where decisions would be made at every level of the government, which theoretically could be challenged in BIT arbitrations or investor state arbitrations. So those were my sort of quick 5 points about why I think we are where we are and why I personally have never found any of this that problematic. And in fact, I suspect this would continue. The only new trend I think you'll see more and more of are investor state claims brought by Indian companies against foreign governments. So that's on sort of the general overview. I know I have just 60 seconds left. So I'll quickly mention the one case that I wanted to talk about, and we can pick this up later. It's the Devas saga, because it's not just one arbitration, there are multiple of those. I picked that up because obviously there are lots of other claims which are in the press, Vodafone, Kane, etc. Devas is perhaps slightly less popular compared to those, but it still is an important illustration, I think, of all the concepts that Rekha, you were talking about, which is, are there instances where the arbitration awards are just too large in terms of size? Are there instances where you have multiple treaty disputes or multiple disputes arising out of the same event? Are there instances where there are corruption and fraud allegations at the heart of what is effectively being alleged, and so on and so forth? So what was Devas? Very shortly or very briefly, in 2005, investments were made by a company called Devas, which is incorporated in India, but has investors based in Mauritius mostly. That investment was in relation to a contract with the Indian Space Research Organization, which perhaps is the equivalent of NASA in the Indian context, to build certain satellites. Now, in 2011, that contract was terminated. I'm sort of skipping, obviously, what happened between 2005 and 11, but 5 is the contract, 11 is when that is terminated. That leads to a contractual arbitration. So the contract between Devas and the Indian Space Research Organization provided for arbitration under ICC rules, I think, but seated in India. That leads to a fairly large arbitration award of about $560 million, which today, along with interest, is about $1.4 billion, I understand. So that's one part of it. That award hasn't been enforced. There are multiple proceedings on foot in India in relation to setting aside of the arbitration award and so on and so forth. Simultaneously, while all of this is happening, the investors in Devas commenced their own investor-state arbitrations against India under the UNCITRAL rules. They too are successful in those arbitrations, so the arbitration award amount is substantially smaller, I think around $100 million or so. And finally, while all of this is going on, very recently, earlier this year and at the end of last year, the government tries to do things which genuinely, I feel, were done in bad faith, for lack of a better word. But effectively what they do is they try and liquidate the company itself, the award creditor, Devas. And the way they do it is by having the award creditor, the award debtor, Antrix, make an application to the company court in India for the appointment of a liquidator. I mean, that's just unheard of. It would never happen in the normal scheme of things. And that, not surprisingly, leads to the threat of another BIT arbitration. I've seen the trigger letter there. I don't know if the arbitration is actually commenced. So what you have there, and we can take this up later, is effectively one contract, the contract for building satellites, giving rise to ICC arbitration, commercial arbitration, giving rise to multiple investor-state arbitrations. You have fairly large investment treaty awards. You have the Indian government saying that the company which has actually lost the arbitration should be liquidated because it has been involved in a fraud, because the underlying contract was obtained through corruption. And that's sort of an afterthought because that allegation was never made originally in the arbitrations. And fourth, just pausing there for a second, is what I think is the next trend, which perhaps is relevant to the cases that Professor Islam, you and Fatima, you would talk about, is just purely efforts to collect on that arbitration award. Because I think, if you really think of how the government mentality has worked in this, you signed on to the BITs, you didn't realize that it could lead to claims. Then it leads to claims. You lose arbitration awards, you spend a lot of money defending yourself. Even then, you don't realize what happens when the investors actually try to collect on that. And then the third phase is that now they're trying to collect on it, and that puts you even in greater pain because that opens up the possibility of execution against state assets. And that's what sort of India is now going through as far as Devas is concerned. Other cases get settled. So we can pick that up as well in the discussion, but I'll pause there. That's all I wanted to sort of say in this much time.
Thank you very much, Rishabh. That you did cover a lot of territory very quickly, so kudos to that. Let's look at Pakistan. Very interesting, very key developments happening there. Tell us, Fatima, what is happening in Pakistan? Where are we headed?
Thank you, Kabir, and really glad to be on this panel. I'm going to keep this brief in the interest of time so we can get to our discussion as quickly as possible. But I think in the case of Pakistan, it's important to give a historical overview to kind of figure out, to kind of understand why Pakistan is doing what it is doing today. So just getting straight into it, Pakistan was obviously signed the first BIT in the world with West Germany in 1959. Understanding Pakistan's frame of head at that time, Pakistan had obviously recently become independent from India, was looking to grow and attract foreign investment, and signing BITs was, at that time, a very fashionable way of getting foreign investment. So what we see is, 60s and 70s, a bit of a cautious approach, but between 1988 and 2001, Pakistan signed around 35 BITs, with 12 being signed alone in 1995. So this is, in stark contrast to India, of course, who they kind of took on signing BITs very slowly. But Pakistan, in the span of decade, accumulated a portfolio of, over 35 BITs. And of course, then in 2001, Pakistan faced, its first major BIT claim in the SGS case, which was kind of like a huge awakening for everybody who had been on this rampage of signing the BITs. And if we look at, interviews of the former Attorney General at that time, Makhdoom Ali Khan, he's obviously made it very clear that, when Pakistan was informed of this claim, people in the government had to literally Google the word ICSID and arbitration to understand, what they had been up to for the last 2 decades. So this was kind of an awakening call for Pakistan. So what happened post that was that Pakistan slowed down the signing of BITs. So what we see is, instead of signing 10 to 12 BITs in a single year, you'd see, long gaps, 6 to 7 years. One BIT signed in 2002, one in 2003, and then, huge gaps in between. So generally there was a cautious approach taken there. But between 2001 with the SGS claim and looking into 2015, although there was a cautious approach, there were slow actions taken. So there weren't the BITs that were terminated or renegotiated. Overall, the mindset of the Pakistani government and the people signing into BITs was that we need to be cautious about what we're getting into. But there weren't major reforms undertaken then. But of course, that all changed very recently with the TCC versus Pakistan, also most famously known as the Ricochet case. That is one case that kind of put Pakistan, accelerated the reform, the ISDS reform in Pakistan. And we've seen in the last, year and a half, 2 years, major shifts happening in terms of the investment arbitration landscape in Pakistan. So of course, Rekha already spoke about this, but I'll just highlight a few points that I think are important in regards to this case. So Ricochet is essentially the name of the area in the state, the province of Balochistan in Pakistan. And it's considered allegedly considered the world's 5th largest gold mine. And in 1993, a joint venture agreement was signed between the government of Balochistan and BHP, which of course was regarding the exploration of this mining area. And later on, BHP sold the rights of Ricochet to TCC. When TCC submitted the mining lease application, it was rejected by the Balochistan government, which of course then led the TCC to file an appeal in the Supreme Court of Pakistan, and then file an arbitration claim in ICSID as well. And the Supreme Court of Pakistan declared that the 1993, the joint venture agreement was contrary to law and public policy and was therefore void. And so then we see a lot of TCC focused a lot on the ICSID arbitration. And so, of course, in 2019, July 2019, a $6 billion dollar award, including interest, was issued against Pakistan. And there's a huge criticism regarding this award, that how such an extravagant award is issued against a country, which there's a lot of question mark on its ability to pay. On an investment of, let's say, $200 million, a fine of $6 billion probably reflects poorly on the potential and neutrality of the ICSID tribunal. The penalty was equivalent to about 2% of Pakistan's GDP. And obviously, as Rekha mentioned, almost equivalent to the bailout package that Pakistan had received from the IMF that same year. So really putting a question mark on how the tribunal could reach this number, and how they and if they even considered Pakistan's ability to pay for this. And when we look at how the tribunal kind of got into this number in the first place, they opted to use a formula for calculating the damages based on the assumed profits of TCC, which they might have earned over a period of 56 years, right? And obviously, experts have argued that there's no sure way to calculate the future price of a mineral, and expected profits are also subject to political uncertainty, and a lot of factors such as environmental impacts are hard to predict. And obviously, by the time this award had been issued, Reko Diq hadn't produced a single ounce of gold or copper, and it was years away from becoming operational. So how do you predict how a particular business is going to do in 20 years? So these are obviously criticisms that this award received. There is also the question of whether arbitrators, who are mostly lawyers, are well versed in making such complex financial projections, because ultimately they're the ones who make final decisions. And also in regards to this case, there was also allegations of apparent corruption in the process of securing the investment. So improper payments made to obtain visa approvals. Subsequently, after this decision was this penalty was given, we saw that the Balochistan Development Authority chairman was imprisoned by the Pakistani authorities for having assets beyond their means, and also being involved in approving the Reko Diq venture agreement. So obviously, this on a local level, these investigations have continued to remain. And as Rekha also highlighted, there's a huge question mark on the ability of the panel to do such high-level investigative work to kind of funnel through the allegations of corruption in these regions. So what we've seen now in response to this case, obviously Pakistan is since Imran Khan, our current prime minister, has come into power, he has been very adamant of attracting more foreign investment. We've obviously seen China as one of the main largest foreign investor in Pakistan. Even just the first half of this year, China invested around $400 million, followed by Hong Kong and Netherlands. So Pakistan their headspace now is to attract huge amounts of foreign investment, but also not be penalized for issues that they have obviously dealt with in the past. So in recent times, Imran Khan has obviously formed a working group, a combination of 15 to 20 people, former state officials, lawyers, that are coming up with suggestions of what kind of reforms that we need. There's also talks, the Board of Investment has also proposed that Pakistan, that initially consider terminating BITs that do not favor it, and pursue strategies to create opportunities for around $50 billion that they're looking to get into Pakistan in the next 5 years. And obviously, in terms of Reko Diq, we've also seen very recently Pakistan's assets being attached overseas, and the whole situation that's been going on with that. So I mean, there's a lot more that can be said with that, but I know we're short on time, so we should probably get straight into the discussion. Thank you.
Fantastic, Fatima. Thank you. Let me just start off. When I got into this panel, right, I was going to make the grand statement that all South Asian countries are essentially the same, facing similar outcomes. But hearing each of you speak, there actually seem to be very unique determining factors impacting how each of these countries look at arbitration. I know I'm being told that we should end soon for networking, but I do want to have a little bit of dialogue between this amazing panel. It is a South Asian panel. Let's perhaps invite every panelist to speak in 1 to 2 sentences. This is the most difficult thing for lawyers, but 1 to 2 sentences. If each of our speakers can tell us their reactions to a statement I am going to present. So my statement for your expert opinion counselors. Investment arbitration is not an appropriate tool for resolution of disputes in South Asian countries. Investment arbitration is not an appropriate tool for resolution of disputes in South Asian countries. Do you agree, disagree? What do you think? Let's go in the reverse order. So Fatima, Rishabh, Rumana, and then Rekha. Fatima, take it away.
So, I mean, I would just say that investment arbitration, although there are many things wrong with the system, and a lot of reforms that can be made, I think in the case of Pakistan, this is a system that one should accept as it is, but consider working to improve it instead of until I think this is the best system that we've developed to resolve issues as complex as we are facing today. Of course, improvements can be made, but I think I think we should work on improving it. But until and unless we develop a better alternative form, I think this works so far.
It works so far. Okay, words of wisdom. Rishabh.
I think it's an appropriate mechanism for resolving disputes involving foreign investors, though of course, as Fatima said, improvements could be made from the perspective of both the investors as well as states.
Thank you. You actually kept it to 2 sentences. That's always the challenge with these things. Professor Islam.
Thank you. In tune with Fatima, I would also like to say, it's like democracy. You don't have any better option for solving investor-state disputes. So let's just make it try to be better. And as I said, have legislation before you litigate, legislate. So as long as you have good protection in your investment treaties regime, it should be fine. And obviously, as a developing countries, they are learning. I think the situation will change in next 3 to 5 years in terms of developing expert councils, at least for Bangladesh, that I can say. So as long as that is taken care of, things might be slightly different, but obviously time will only say that how far it's working.
Time will say, indeed. Thank you. Rekha.
I think I'm going to echo what the panelists said. Absolutes are never
Everybody's
ones.
agreeing. This is a very agreeable group.
Absolutes are never ones we like to adhere to. We make all sorts of disclaimers at the start of panels and papers to that effect. So, but notwithstanding, there's an inherent asymmetry in the bits and the MITS system. There's the better system available in the fora now. But certainly we are going through a major evolution of model treaties. And it'll be very interesting to see, to borrow from Rishabh's comment, the patchwork that is being made in the evolution.
Awesome. Let me present another statement to get your reactions, right? Because I think something we spoke about was tribunals stepping in, tribunals interpreting, tribunals, looking at obligations stated in treaties. And because of that, let me just present another proposition. It's a little cheeky, but treaty interpretation is a necessary consequence of poor drafting of treaties, particularly in South Asian countries. Do you agree with this statement? Rekha, perhaps we now go the other order.
Well, the disclaimer I would make is without actively engaging in these treaties, many treaties start out with bad drafting, as do many arbitral clauses. And you're stuck with them, so to speak, for a period of time until you learn better, and then implementation takes over, and then add another decade. So it is an evolutionary process, but inherently you have to start somewhere, is what I would argue.
Thank you. Professor Islam.
I think I already said, before you litigate, legislate. So as Rekha said, that it's an evolutionary process. So we had first generation, second generation, third generation of BITs. Maybe in future we will be having a fourth generation of BITs. So we should always have that space in the BIT that we can adapt that in course of time, how to, with the changing circumstances, because this whole pandemic has put us into many situations which we could not even imagine when we had all these BITs. So this would be again something I am sure would be addressed in the coming BITs about all this kind of the challenges that this pandemic has imposed and exposed.
Thank you. Rishabh Gupta.
I would disagree with that statement. I don't think the treaties were badly drafted in the sense that they weren't riddled with errors or they weren't inherently inconsistent. They just didn't reflect perhaps what state parties today would want from those treaties. Equally, I don't think there was anything specific in those treaties which you can point to as far as South Asia is concerned, because the first generation BITs look fairly identical across the board, whichever jurisdiction you might have gone to. Evolutionary process, of course, but that's true for any instrument which receives continuous interpretation and application through judicial bodies or arbitration tribunals. So that process wouldn't stop. So yeah.
Thank you. Fatima Aslam.
I would say that more than poor treaty drafting, like as Rishabh mentioned, at least in the case of Pakistan, I would say the South Asian countries can definitely be better at negotiating the treaties and making sure that their interest is reflected accurately in the words. Because I guess as lawyers, we all know how much words matter. So definitely making sure that your interest is reflected well in the, because historically in the case of Pakistan, we've always, gotten a rude awakening call much later on what we have signed. So we want to make sure that going forward, we are able to kind of negotiate in an equal space.
Well, folks, you've heard it from the experts right here. I invite everyone to give a virtual round of applause to this amazing panel. We have covered probably one of the most pivotal and significant regions that is playing a very important role in ISDS. So thank you, panelists. I definitely feel I have learned a lot. With that, let me invite Jose Antonio Rivas to tell us what's going to happen next. But let me echo once more. Everyone, round of applause to this amazing panel right here.
Wonderful. Kabir, thank you so much for moderating this in, I say this truly in unique style, absolutely unique style. I don't think that anybody would be able to do it as you do it, which is really wonderful. Thank you so much. And in the order that you appear, Fatima, very glad to see you and listen to you making the statements and sharing your thoughts, especially concerning investment arbitration in Pakistan. Rekha, has been a pleasure. Thank you so much. Sometimes you speak and it sounds like poetry. So really, it's wonderful. Rishabh, very nice to meet you, and I really like the definitive voice in which you answer many of the questions. So wonderful. And Professor Islam, as always, as I said at the beginning, it's a pleasure to meet you and to have you here and share your perspective concerning Bangladesh and investment arbitration. Now I would like to. This is a panel to see many times more. I'm glad that we'll have it on video and that we'll have many of the sources available for people to update themselves, especially concerning South Asia. Now we would like to welcome everyone to the breakout rooms. We're going to have perhaps at the most 2 or 3 breakout rooms, and we're glad that it's now not that early in South Asia, and I'm getting a little bit late here in Eastern Standard Time, but still very exciting. So with that, thank you to all of you, and let's move on to the breakout rooms.